All right, so today's timely topic is on the topic of freedom of speech. So it's kind of a pretty busy topic right now around the world of what constitutes free speech, what's protected, what's not, what limits can be placed on it. And this is not just something that's happening in America, it's happening all over the world right now, these kind of conversations. So I was in Istanbul 2 weeks ago while they were having these massive kind of protest marches, right? So the Turkish president had arrested the kind of leading candidate of the other party, the mayor of Istanbul, saying they had evidence of corruption, wouldn't share that evidence. People are like, this seems kind of shady. So all these people out on the streets, they make it a rule that you can't gather anymore. So now they're cutting down that. People gather anyway, so they're getting arrested. They shut down all these streets. So my hotel's across the street, but I got to go an hour around because they cut all the bridges over the Golden Horn. So, but again, people are like, we have to demonstrate this kind of protest, this walking, this chanting, but also realize that you get them in trouble. And people are arrested. So these things are worldwide discussions. I'm out of copies. I can email you one. We might be able to grab one if there's anybody has one they can share. So, overview of free speech in the First Amendment and its interpretation. So, to begin with, it says, Congress shall make no law abridging the freedom of speech or of the press. So what does this mean today? Generally speaking, it means the government may not jail, fine, or impose civil liability on people or organizations based on what they say or write, except in exceptional circumstances. So although the First Amendment says Congress, the Supreme Court has held that speakers are protected against all government agencies and officials, federal, state, local, and legislative, executive, or judicial. The First Amendment does not protect speakers, however, against private individuals or organizations such as private employers, private colleges, or private landowners. The First Amendment restrains only the government. So if you get fired for something you say at a workplace that's not the government, and you're like, well, I have freedom of speech. Sorry, still can be fired. So the Supreme Court has interpreted speech and press broadly as covering not only talking, writing, and printing, but also broadcasting, using the internet, other forms of expression. So again, back when the Bill of Rights, there was no Facebook. Now there's internet. All these things has to kind of come into play. Also, the freedom of speech applies to symbolic expressions, such as displaying flags, burning flags, wearing armbands, burning crosses, and the like. The Supreme Court has held that restrictions on speech because of its content, that is, when the government targets the speaker's message, generally violate the First Amendment. Laws that prohibit people from criticizing a war, opposing abortion, advocating high taxes are examples of unconstitutional content-based restrictions. Such laws are thought to be especially problematic because they distort public debate and contradict the basic principle of self-governance that the government cannot be trusted to decide what ideas or information the people should be allowed to hear. So we talked a couple of weeks ago about those Alien Sedition Acts of 1798. Part of that was kind of banning papers from being able to criticize the government. That quickly went erased. People realized that's not good when the government controls the debate, when the government controls the conversation and what can be said. So there are generally three situations in which the government can constitutionally restrict speech under a less demanding standard. The first is, in some circumstances, the Supreme Court has held that certain types of speech are of only low First Amendment value, such as defamation, true threats, like threats to commit a crime. For example, I'll kill you if you don't give me money. That is not free speech. That's a 1969 Supreme Court case. All these are Supreme Court cases where this decides after it. Fighting words like face-to-face personal insults that are likely to lead to an immediate fight are punishable. That's a 1942 Supreme Court case. But this does not include political statements that offend others and provoke them to violence. For example, civil rights or anti- or pro-abortion protesters cannot be silenced merely because passerbys respond violently to their speech. That's a 1965 case. If you're out there protesting something and people then cause violence, Do you still have the right to say that? So even in the case, if you have Nazis marching down the street and people then attack them because they're Nazis and they're bad, sorry, the Nazis have the freedom to share that and to make that march and to chant those things, unless they're calling for people to be hurt. So that protects that kind of speech. Then there's others like obscenity, pornography. Some of those things are considered those low value. A second area is the government can restrict speech under a less demanding standard when the speaker is in a special relationship to the government. Government employees, students in public schools, teachers, when their speech is incompatible with their status as public officials or students. So a teacher in a public school cannot be like, kids, you should all try meth. It's a great idea. Go do it. That is not protected under free speech if you're one of these government employees. Now, if you're just on the street and you tell a kid to do that, that would be an interesting case. Now, you're telling them to commit a crime potentially. They might be able to get you on that. But if you're just saying, meth is cool, kids, protected, free speech. Number 3, the government can also restrict speech under a less demanding standard when it does so without regard to the content or the message of the speech. So content-neutral restrictions such as restrictions on noise, blocking traffic, large signs. So you can't say, I can blare my music as loud as I want at 3 a.m. in this small village because it's free speech. It's not, according to that Supreme Court interpretation. There's some fun cases there. If you're interested in more about it, you can look those up. So courts have not always been this protective of free expression, though. In the 19th century, for example, courts allowed punishment of blasphemy. So if you say something that Pastor Stephen thinks is blasphemous, punished. Perfectly allowable. That would be scary. And during and shortly after World War I, the Supreme Court held that speech tending to promote crime, such as speech condemning the military draft or praising anarchism, could be punished. So, things have changed. Moreover, it was not until 1925 that the Supreme Court held the First Amendment limited state and local governments as well as the federal government. So before 1925, you could be punished by the state for speech, but maybe not the federal government. So that wasn't until 1925 that states are included in this. So you see a progression, an evolution of what the understanding of freedom of speech is. And that should be kind of logical, right? Because anytime you're interpreting a document, your interpretation changes as you have more experiences, and contexts change, right? There's no internet, so you don't think about how that affects freedom of speech. It's the same thing with scriptures, right? We change how we interpret scriptures over the past 2,000 years. Up until the 1960s, a woman couldn't serve as an elder or a pastor in the Presbyterian Church. We changed how we interpreted scriptures. We've changed how we interpret the Book of Order at times, with new information, with new calls of the Spirit, just new contexts. So it's not necessarily this bad thing that the Supreme Court is sometimes changing, because we all change in our interpretation of documents. When you read something when you're in 5th grade, hopefully you have a different understanding than when you're 25 or 55 or maybe even 85. So that can evolve and change. But as I said in the class this morning, it can also be problematic sometimes when you have different makeups of justices going back and forth on issues because there's no consistency. That's one argument for lifetime appointments, that you can kind of have this consistency over a long period of time. There's arguments against that too. As I said this morning, that's one of the downsides of democracy. We change who the executive is every 4 to 8 years, so it's hard to have long-term plans about trade or national security because different people come in with different ideas, so it's hard to be consistent. Everything has pros and cons. So, starting in the 1920s, though, the Supreme Court began to read the First Amendment more broadly, and this trend really accelerated in the 60s. Anybody alive in the 60s? That whole freedom of expression thing? I wasn't there, but I heard about it. It was fun, says Greg, yes. So today, the legal protection offered by the First Amendment is stronger than ever before in our history, but there's concern that trend is changing over the last couple years. So we're going to look at kind of one case that in some ways is kind of emblematic of some of the challenges, limits, potential of free speech. So it's Texas versus Johnson. Anybody remember this one? 1984. I think we were all alive then. I was 2. So Gregory Lee Johnson burned an American flag outside of the convention center where the 1984 Republican National Convention was being held in Dallas, Texas. Johnson burned the flag to protest the policies of Reagan. He was arrested and charged with violating a Texas statute that prevented the desecration of a venerated object, including the American flag, if such action were likely to incite anger in others. So you can imagine people, light a flag on fire, burn a Bible. We had the issue of the pastor burning the Qurans in Florida a while back. Didn't get in trouble for that, but no one even said anything. But the idea is if it's a venerated object that might incite anger, Texas says no can do against the law. So Johnson was arrested and found guilty. He appealed and went all the way to the Supreme Court. Now, if you're not familiar with Supreme Court cases, they don't work like normal trials. We have all these kind of witnesses and cross-examinations. This is more the justices asking questions to the lead lawyer. So I have some transcripts of some of the questions and answers to kind of get a sense of how each side is arguing. So the first question asked by a justice was, can the government prohibit the act of flag burning as an infringement on the free speech clause of the First Amendment? Texas lawyer says yes. It says the court has interpreted the First Amendment to grant a higher level of protection to speech than it grants to conduct because not all conduct is considered a form of speech. The First Amendment does protect symbolic speech, but some actions do not always rise to the level of symbolic speech so as to require protection under the First Amendment. Flag burning is the destruction of a symbol of national unity. Even if the flag that is destroyed is private property, the government has legitimate interest in regulating its protection because of what the flag represents to the nation. Lines must be drawn when it comes to expressive speech to make sure that otherwise criminal conduct is not couched in First Amendment terms. So they're arguing basically, even if it's private property, this has a kind of a national property as a symbol, and not all actions are symbolic, but they employ what's called the slippery slope fallacy as well, that says, well, if you allow this, other people can say things that are criminal are just free speech. I'm expressing myself when I say something or do something hateful on my private wall or whatever it is. They're kind of saying this could slip down a dangerous slope. The lawyer for Johnson says, no, the government cannot prohibit that. The court has recognized that the First Amendment protects certain forms of symbolic speech. Flag burning is such a form. When a flag is privately owned, the owner should be able to burn it if the owner chooses, especially if this act is meant in the form of protest, so long as public and or the property of others is not destroyed in the process, or there's a danger to others by setting the flag on fire. The government cannot prohibit this action without infringing upon free speech rights. Next question is, should flag burning as symbolic speech be prohibited as an exception to the First Amendment's free speech protections? Texas says yes. Even though the First Amendment protects symbolic speech, an exception should be made to prohibit burning of the flag. The flag is a symbol of national unity that represents the ideals for that which the United States stands. Moreover, it honors those who died in defense of this country. The protection of these concepts as represented in the flag constitute a compelling governmental interest that justifies a ban on flag burning desecration. That was a really weak argument they offered, and it's interesting if you want to go look to see how some of the justices in that moment responded to that argument. I don't have time to put everything in here. You can go look it up, but they didn't really buy one that let's just start making exceptions. That the court shouldn't make the exception. It should be Congress that makes the law and not the courts who decide an exception. And two, just because something is a symbol for some doesn't mean it's a symbol for all, and how you use that symbol can be changed. So it's interesting to read some of the justices' comments on that. Johnson lawyer says no. As noble as the argument is, the First Amendment does not recognize an exception for prohibitions on flag burning. When the defendant burned the flag in this case, he was making a political statement. Moreover, as ironic as it sounds, being able to burn the flag, the defendant and other persons like him, is actually honoring the values the flag is meant to protect. For instance, the flag represents freedom of speech, including giving protections to those who desecrate it. On a more practical note, why should this one action be accepted from the First Amendment's protections? Could or should other exceptions be made? Who would make these decisions? Next question is, should the allowance of flag burning depend upon the reasons for and potential reactions to the act? So sometimes the courts are looking at, well, in theory this is okay, but what about the reactions that come later? Will this end up being overall damaging, or could produce violence or something like that? We'll get to that later on France. So Texas says, yes, the Texas Act permits the destruction of worn-out flags in a prescribed manner. The Act also acknowledges that prosecutions of flag burning only occur when this action would be likely to offend others, and it goes on. Johnson says, no, the Texas Act clearly discriminates on the basis of viewpoint. It allows respectful but not disrespectful destruction of the flag. Its antipathy towards disrespectful destruction of the flag is further highlighted by the fact that it prohibits actions that are likely to offend others. First Amendment rights cannot be based on the reactions of others. So, here are a couple key arguments from the case. So Kathy Drew's the lawyer for Texas. Her main kind of argument, she says, we believe that preservation of the flag as a symbol of nationhood and national unity is a compelling and valid state interest. We feel very certain that Congress has the power to both adopt a national symbol and to take steps to prevent the destruction of that symbol, to protect the symbol. We believe that if a symbol over a period of time is ignored or abused, that it can in fact lose its symbolic effect. Because I believe that every desecration of the flag carried out in the manner that he did here, and I certainly don't think there can be any question that Mr. Johnson is a hardcore violator of the statute, if his action in this case under the facts do not constitute flag desecration, then really I'm not quite certain what would constitute flag desecration. Texas is not suggesting that we can insist on respect. We are suggesting that we have the right to preserve the physical integrity of the flag so that it may serve as a symbol because its symbolic effect is diluted by certain flagrant public acts of flag desecration. Now, I'm not going to go through all this here, but read the opinion pieces by the justices, and they kind of, Brennan kind of tears the end of that argument apart, because if a symbol can be that diluted by a couple people burning it, it's not a great symbol to begin with. William Kunstler says, for Johnson, I understand that this flag has serious important meanings, that it's not just pieces of material, blue and white and red, but it may have different meaning to other people out there. I think it's a most important case. I sense it goes to the heart of the First Amendment. To hear or see things that we hate tests the First Amendment more than seeing or hearing things that we like. It wasn't designed for things we like. They never needed a First Amendment. This amendment was designed so that things we hate can have a place in the marketplace of ideas. So the decision ended up being a 5-4 decision in favor of Johnson. So Brennan was the author of the majority decision. He was joined by Marshall, Blackmun, Scalia, and Kennedy. Kennedy wrote a concurring opinion piece. There's pieces of it in here. The dissent was authored by Rehnquist. Then also joining him was White, O'Connor, Stevens, who was the author of another dissent. What's interesting here is, this is a fun case where you really do have a kind of an interesting ideological split of what's typically conservative liberal judges. You have some liberals on the dissent and some conservatives on the majority. It really is an interesting mix there. So the majority of the court, according to William Brennan, agreed with Johnson, held that flag burning constitutes a form of symbolic speech that is protected by the First Amendment. The majority noted that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for suppressing free speech. So I have in the rest of here key excerpts from the two majority opinions and the two dissenting opinions. I always find it helpful to read bits of both, so you understand what the rationale is thinking is from both sides. Sometimes in history, the dissent ends up having a larger outcome on future cases than the majority opinion. So all of these opinion pieces are really important. It helps you kind of understand why something is done. So in this case, I think it's really important to note the justice decided that speech that we might not really like, that we might find abhorrent, that's when the clause is most important. And that goes with things today. We hear things we may not like, but you can't just shut them out. And there has been a trend of trying to shut out ideas. So there's a kind of a trend that started in 2015, especially on like major universities, where people would say, we don't want this person to come and speak. It offends us. We're going to protest it down. It's their right to protest it down. The problem was the colleges kind of said, okay, we won't. And you start having no challenging ideas anymore. The marketplace of ideas is shrinking and shrinking and shrinking. If you want to know more about this, there's a great book by Jonathan Haidt, who we're reading, The Righteous Mind, this April. He wrote one called The Coddling of the American Mind, kind of about this phenomenon. And I see it a lot. I had a friend in Peoria, as we were working with kind of Peace for Peoria, kind of trying to combat Islamophobia, would just say things like, we can't even allow, Nazi thinking to exist. We can't engage with them at all, pretend they're not here. It's like, that's not helpful, because they're going to exist whether you talk to them or not. And if you say they're so bad to even hear, what's to say they don't think we're so bad they're not going to hear, and no one hears each other, but these things just grow. By pretending, by refusing to hear something, doesn't mean it stops existing. And we can't say we don't like it, so we're not going to hear it. We're not going to allow anybody to hear it. That always becomes a dangerous thing. And that's where there's some interesting court cases around the world happening right now about what role do courts play in people's free speech, free gathering, and how that affects politics. If you've been keeping up with what's going on in France, right? Anybody keeping up? So Marine Le Pen, a far-right candidate, was really the favorite to win the presidency after Macron. He's term limited. She was found guilty by a court of embezzling whole millions of euros from the EU to staff and things that weren't that kind of work. So the courts basically said, we find her guilty. She's barred from holding office for 5 years, maybe jail time. And they noticed, they said, we realize this could have major effects on the political landscape. That taking a candidate out of the running, some could say we are inserting ourselves, the courts, into politics by not letting the people have a voice. But they said ultimately it's the judicial branch's job to try and convict certain things like this and sometimes protect the people when you have criminals doing stuff. So you have some people in America saying, you see, judicial overreach, you're taking the voice away from the people. Same thing I think happened in, is it Romania? They recently declared a recent election null and void because they said there's enough evidence that Russia interfered with the election and did all this stuff, so now the election, so some people saying, hey, now the courts are just not even allowing the results of elections. But if there's cheating, it's hard to know, because then you can also say there's cheating when there's no evidence of cheating. So we have this tough situation of what role does the court play, what role does free speech come in, and outside countries' roles. If Russia or Taiwan or any place wants to come in and affect the elections, they have a right to do that by saying things and trolls. If it's all these, this is a new kind of free speech. Can you have AI? Is AI protected in free speech if you have these troll bots going around in America from another country? I think that's going to be a case at some point if it's not already out there somewhere. So you have that happening, but then you also have in Turkey the president jailing the opponent. So what's really interesting is you have some in America saying, oh, look how bad the courts are taking out people. And they're silent on what Turkey's done. On the flip side, you have some being like, oh, Turkey's bad, but they're silent on the courts. It's all kind of how again, we find our right reason in our gut, then we find evidence that what we feel is okay. So it's very complicated, right? What roles do courts play? What roles do free speech play? And it's changing all the time. We're seeing that a lot now with cases on protests. Can foreign students who have legal green cards express views the U.S. government doesn't like, even if they support a terrorist group, if they're not actually physically supporting them, and aren't actually doing the act, but say, we understand them, we are on their side, or is that protected or not? Or can they be shipped out of the country? At what point is protest legal or illegal? Sometimes it causes physical damage to property. People have been hurt. Is the leaders of the protest liable? Or is it just the people who actually did this stuff? So all of this is coming up right now. How we express dissent, how we express approval, what we are allowed to say or criticize or support. And the tides are changing in how free speech is being recognized. And it's changed before, it'll probably change again. But as kind of Christians, we have to kind of think about what is our role in what we say and in what we do. How do we speak that in truth and in love? Sometimes in boldness. Sometimes there may be negative consequences, but being aware of those consequences. Throughout history, Christians have been jailed for saying things that the powers that be didn't like, whether it's in this country, Paul with Rome. He was chased out of Ephesus because he was saying stuff, and the silversmiths didn't like that very much because he was telling them not to buy these idols. It all comes down to money, right? They're like, people are not buying our idols because you're telling them not to. We're going to chase you out of town. Throughout history, you can be punished for the things you say. We might say there's freedom of speech, but has there ever truly been? Just like Gandhi got in jail, Martin Luther King Jr. was put in jail, never really broke a law sometimes he did. These are the questions before us. And it's not going to be easy answers in the future. And I'm no constitutional or a Supreme Court scholar. I just try to read up on it. So keep having the conversations. Keep reading things because it's happening constantly. There's new kind of decisions on court cases. And you kind of see where people fall and what the shifting tide of the legal landscape looks like. Questions, comments, freeing remarks. All righty, thank you all very much.